In the wake of recent riots, looting, and violence, there's controversy about the responsibilities of local, state, and federal governments to protect people and their property. What exactly are the duties of these officials? Let's look at just facts. According to President Trump, his first and highest duty as president is to defend our great country and the American people. He also says a number of state and local governments have failed to take necessary action to safeguard their residents, and that he will protect the rights of law-abiding Americans if they do not. This statement mirrors the Declaration of Independence, which established the foundational principles of the U.S. government and its obligations to the people. Like Trump's speech, the openings of this document states that governments are instituted to secure people's rights. Likewise, James Madison, the primary author of the Bill of Rights and father of the Constitution, stated at the Constitutional Convention that the defining purpose of the new government they were forming was to provide more effectually for the security of private rights and the steady dispensation of justice. He also wrote in the Federalist Papers that the first object of government is the protection of the faculties of men, from which the rights of property originate. However, the framers of the Constitution and the Bill of Rights left most of those responsibilities to the states, many of which were unwilling to join the Union unless they maintained a large degree of independence. Recognizing that agreement, the U.S. Supreme Court ruled in the 1833 case Barron v. Baltimore that the rights of the people in the Bill of Rights only had to be respected by the federal government. They could still be infringed by the state governments. But that changed after the Civil War, with the 13th Amendment's nationwide ban on slavery, and the later passage of the 14th Amendment, which forbids states from enacting or enforcing any law which shall abridge the privileges or immunities of citizens of the United States, depriving any person of life, liberty, or property without due process of law, and denying any person within its jurisdiction the equal protection of the laws. This amendment also gives Congress the power to enforce those provisions by appropriate legislation. Congress has passed multitudes of such laws, and the President is responsible for implementing and enforcing them. The main reason for the 14th Amendment was that states were violating the rights of the newly freed African Americans and failing to protect them from groups like the Ku Klux Klan that were terrorizing and killing them. Hence, Congressman John Bingham, who drafted the 14th Amendment, repeatedly stated that it would require state governments to provide equal protection to every person's life, liberty, and property. The same applies to local governments, which are offsprings of the states. Despite the 14th Amendment and the Founders' declarations that the main purpose of government is to protect people's rights, there are some that claim the Constitution doesn't require any level of government to defend people's life, liberty, or property. For prime example, P.E. Moskowitz writes in The Nation that nothing in the First Amendment prevents citizens, members of Antifa or otherwise, from interrupting someone's protest. Nor does it guarantee police protection for white nationalists. It only limits the ability of Congress from passing laws that interfere with speech. This blatant half-truth ignores the 14th Amendment, which requires all governments to equally protect the constitutional rights of all people. Other such arguments are rooted in misinterpretations of court decisions. One of the most common is Warren v. District of Columbia, in which the majority of judges on a federal appeals court dismissed a lawsuit against the district that stemmed from its failure to protect 3 women from 2 men who held them captive, beat, and raped them for 14 hours after they called the police for help. According to Scott Unzicker, writing at Guns.com, the Warren ruling means that police have no legal obligation to protect and serve the population. However, the ruling says just the opposite, but notes that this duty cannot be enforced through a private lawsuit for negligence, except under special circumstances. In the words of this oft-cited but rarely quoted ruling, although recognizing the obligation of public employees to perform their duties fully and adequately, the law properly does not permit that obligation to be enforced in a private suit for money damages. The duty to provide public services is owed to the public at large, and absent a special relationship between the police and an individual, no specific legal duty exists. Dereliction in the performance of police duties may, therefore, be redressed only in the context of a public prosecution and not in a private suit for money damages. Others cite the Supreme Court's 1989 ruling in DeShaney v. Winnebago as evidence that the Constitution does not require government to defend people. In reality, however, this ruling was far more narrow and merely declares that the Due Process Clause of the 14th Amendment doesn't require this. However, it also states that the Equal Protection Clause does require this. The ruling accords with John Bingham's answer to a question posed to him by Congressman Robert Hale, a leading opponent of the 14th Amendment. When Bingham introduced the amendment in the House, Hale asked him if it gives Congress powers to protect people's life, liberty, and personal property. Bingham replied that it certainly does, and added that it confers upon Congress power to see to it that the protection given by the laws of the states shall be equal in respect to life and liberty and property to all persons. Hale then asked what part of the amendment contains this provision, and Bingham answered, "The words equal protection contain it, and nothing else." Furthermore, the rulings in DeShaney and Warren apply to specific circumstances and say nothing of the general duty of government. This duty was spelled out in the Supreme Court's 1911 ruling in Chicago v. Sturgis. Primarily, governments exist for the maintenance of social order. Hence it is that the obligation of the government to protect life, liberty, and property against the conduct of the indifferent, the careless, and the evil-minded may be regarded as lying at the very foundation of the social compact. Speaking even more directly to Trump's remarks, the same Supreme Court ruling says that it is the obligation of the state to preserve social order and the property of the citizen against the violence of a riot or a mob. During the 150-plus years since the 14th Amendment was enacted, the Supreme Court has issued various rulings that waver between enforcing the rights it acknowledges and disregarding them. Some of these rulings are textbook examples of judicial activism, where certain justices prioritized their personal views over the Constitution, and the result was people's rights were violated. For instance, the court's 5-4 decision in the 1875 case of United States v. Cruikshank trampled on the 14th Amendment and unleashed white militias and mobs to subjugate black people through violence and intimidation for decades. However, many of those rulings have been effectively overturned. So in summary, U.S. founders, the primary author of the 14th Amendment, and the U.S. Supreme Court have made it clear that the core purpose of government is the protection of people's life, liberty, and property. In the Indiana Law Journal states, "The right to engage in lawful conduct and to be protected therein against the lawless is the fundamental reason for the existence of organized government." Furthermore, it states that if government doesn't do this, it has failed in its basic function. To buttress that statement, the paper cites a 1939 brief by the American Bar Association, which declares that people need not give up their lawful rights simply because the lawless insist on attacking them. Traditionally, officials must enforce the law the lawful way, not the easiest way. Thus, the brief says that when people's rights are threatened by violence, the only proper remedy for such a situation, small or serious, is the police protection to which citizens are entitled, whether they are singly or in groups. The U.S. President has called on governors to honor their constitutional duty to do just that. I'm Amanda Reed Sheik, here with Just Facts. For thorough documentation of every fact in this video and more facts about this issue, read the article "Media Outlets Stir Racial Strife and Slander Trump for Urging Governors to Protect People's Rights" at justfactsdaily.com.